This is Professor Kenneth S. Abraham, the David and Mary Harrison Distinguished Professor of Law at the University of Virginia School of Law, to discuss Byrne versus Boadle. Welcome, Professor Abraham.
Thanks, I'm glad to be with you. Byrne against Boadle was a case decided in England in 1863. And it established a legal doctrine known as res ipsa loquitur, which is Latin for the thing speaks for itself. So let me tell you about it. In Byrne against Boadle, the plaintiff was walking along a road, and he passed by a flour warehouse. And while he was passing by, a barrel of flour rolled out of a window. The case doesn't say, but it must have been a second-story window, or at least something above where the plaintiff was, and fell on the plaintiff and injured him. The plaintiff sued the owner of the warehouse for the negligence of its employees. It was established by then that an employer is liable for the torts of its employees. But the plaintiff wasn't able to prove with any particular evidence anything other than the fact that the accident occurred. And the lawyers for the defendant moved to dismiss the case on the ground that there wasn't any evidence that the defendant had been negligent. As the lawyers for the defendant said, for all anyone knew, it was a customer of the defendant who was lowering a barrel of flour out of the window rather than the defendant's employees. And so the court was faced with the question, well, in a situation like this where there isn't any eyewitness testimony or any particulars about the way in which the defendant was allegedly negligent, is that sufficient to support a jury finding that the defendant was negligent? And the defendant's position was, no, you've got to prove what I did wrong. And the court held, no, the case could go to the jury, and the jury found for the plaintiff, because there are cases in which the thing speaks for itself. In Latin, res ipsa loquitur. And so this established the proposition that there are times when the particularities of the negligence that's to be attributed to the defendant don't have to be proved, as long as it's more likely than not that the defendant was negligent in some way. Now, that's an interesting situation in which to establish a doctrine, because it wasn't only a question whether the defendant was negligent, but whether, so to speak, it was the defendant who was negligent as opposed to somebody else, like a customer. But the court said that the thing speaks for itself, and if the defendant wasn't negligent, or it was a customer that was involved in lowering the barrel, it was open to the defendant to come in and prove that. So for many decades, this doctrine of res ipsa loquitur applied and was available, but only under very limited circumstances. Well, maybe not so limited, but in any event, specified circumstances. The event had to be one that ordinarily happened because of negligence, not because of something else. It had the instrumentality that caused the harm had to be in the control of the defendant, and the plaintiff had to have no involvement in causing his activity. But in the last few decades, it's become recognized that res ipsa loquitur is really just a particular instance of circumstantial evidence. In effect, the general proposition that we get from Byrne against Boadle is that sometimes you can prove the particular way in which the defendant was negligent, but if there isn't a particular way proved, but it's the kind of accident that only happens, or ordinarily happens, because the defendant was negligent in some way, it isn't necessary to prove the particular way in which the defendant was negligent, but the defendant can always come in as part of its case and show that it exercised reasonable care or that somebody else was responsible. And so res ipsa loquitur is now understood to be an example of the proposition that sometimes you can prove negligence with circumstantial evidence. And of course, that's a very significant point.
Thank you very much. And that case still has precedential value?
It has precedential value. Res ipsa loquitur, with variations here or there, is a doctrine that's in force in all American states as well as in England. And it's a proposition that all lawyers know about and all first-year law students learn in their torts classes.
Excellent. Thank you very much, Professor Abraham. This is very informative, very useful, and exactly what I was hoping to hear.
My pleasure.
So thank you. That was great.